All right, well, we need a defense attorney. Oh, Ms. Rawls and Mr. Harris.
Yes.
Good morning, Your Honor.
Good morning, Mr. Harris, Ms. Rawls. What case are we calling first, Ms. Flynn?
I believe we can just start heading down the line. We can start with Leslie Anderson.
All right, so we're on the record in 23-01871. That is people of the state of Michigan versus Leslie Anderson. Appearances for the record. Ms. Flynn.
Thank you, Your Honor, and good morning. Gabrielle Flynn, Assistant Prosecutor here for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Leslie Anderson, who's standing to my right. Mr. Anderson, if you please state your first and last name for the record.
Leslie Anderson.
All right, thank you. This is the time set for a final pretrial in the matter. Ms. Flynn, how are we proceeding?
Your Honor, at this time, the people have not had successful contact with the complaining witness in this case. We have attempted a phone contact with them multiple times and have not been successful. We have also not had any success with getting a subpoena to them. At this time, we do expect a motion from the defense.
All right, and the witnesses were subpoenaed in this matter, is that
They
correct?
were, yes, Your Honor.
All right, Mr. Harris.
Yes, Your Honor, given the complaining witness has failed to appear at this time and the prosecutor hasn't had any contact, I would request the case be dismissed at this time and a copy of the dismissal be provided to my client.
All right, I'll have printed out the dismissal without prejudice. So, Mr. Anderson, I'm having printed out at your request a dismissal without prejudice. This means the people could reissue if they choose to, but for our purposes today, the case is dismissed. And I'll sign the dismissal. I do have a no contact order, but I don't have a GPS. So you should carry a dismissal with you, okay? Because it takes about 4 hours to purge from the court system, from the computer system, and this will let them know that it was dismissed. All right. Anything else for the record in 23-01871, Ms. Flynn?
Not for the people, thank you.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, we'll make you a copy of this and you can fit on your person, okay? All right. Who's next, Ms. Flynn?
I believe we can go to Mr. Johnson, Joel Johnson.
Right, so we're on the record in docket 26-01590. I have it set for a PA 53 contempt violation and a final pretrial. Mrs. L, your appearance for the record, or Ms. Flynn.
Thank you, Your Honor. Gabrielle Flynn, Assistant Prosecutor for the people.
Ms. Rawls.
Assistant Public Defender Linda Rawls, appearing on behalf of Joel Johnson, who's standing to my right.
And sir, you are Joel Odom Johnson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a final pretrial and a PA 53 contempt violation. Ms. Flynn, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date, and I have had proper contact with them. They did indicate to me on the 31st, that being Friday, that they would be here and present today. However, they have not appeared. I will say that when I did talk to them, she confirmed that she did not receive her subpoena. And with the PA 53, Your Honor, we would ask for one more final pretrial. However, I do know defense will be making a motion.
All right. This has been set since it was initially set for final pretrial on June 29th. It was set for second final pretrial on August 3rd. And then that puts us here today, August 3rd. Ms. Rawls.
Your Honor, given that the victims have failed to appear, the defense moves to dismiss.
All right. Ms. Flynn, you had some contact with the victims last week, is that correct?
That is correct. On Friday, I was able to speak to the victim and she indicated that she was going to be here, but she is not here today.
Okay. Well, I'm going to grant the motion to dismiss. dismissed without prejudice, which means that people could reissue if they choose to. They'd have to reevaluate the case, but this is the case. The victim contact was made with the victim. Any contact to get her here has been unsuccessful. But Mr. Johnson, usually we just go to like it's a default to dismiss without. This may be reissued, okay, and then you start through the process all over again, okay. The case would have to be reevaluated by the prosecutor's office, obviously, but I'm going to grant the motion to dismiss based on your counsel's request. The PA 53, I would assume you can't go forward on it.
That is correct. Yeah.
So I'm going to dismiss the PA 53. That's dismissed, also dismissed without prejudice. But the people aren't able to go forward with that without the complaining victim. But this would be adjourned again, but it's been adjourned before. It's been adjourned twice before. So I'm not going to adjourn it again. Okay. But it may be reissued if the victim comes forward and indicates. I'm not sure. All right. It's dismissed without prejudice. I'm going to sign the order of acquittal or dismissal based on defendant's motion. I have a no contact order, but I don't have a GPS. So
No, you don't.
Yeah. So you should carry one of these with you, just so you have some indication what we did here today, because it takes about 4 hours to purge from the court system. All right.
Okay.
All right. Anything else for the record? In 26-01590, I've dismissed with at the defendant's motion. I've dismissed that file without prejudice, and then with PA 53, I've also dismissed, indicating that there's an indication that the complaining victim indicated she was going to be here, and she's not. And the people are not able to go forward.
Okay.
Anything else on the record concerning this matter, Ms. Flynn?
Not for the people. Thank you.
Ms. Rawls?
Nothing for the defense, Your Honor.
All right, Mr. Johnson, you should all set. We'll provide a courtesy copy so you can keep this on your person. Okay. Interpreter here.
Yes.
Is Luxon here?
I believe so.
All right, let's go on that one. I'll throw the interpreter in and. All right, so interpreter, I'm going to have you indicate your first name and last name for the record.
Marie Christoph,
Okay, and spell them both for me.
MARIE CHRISTOPHE.
Is that TOPHE or TUPHE?
TOPHE.
TOPHE. All right. And what language are you interpreting in?
Haitian Creole.
Haitian Creole. All right. Please raise your right hand, ma'am. Do you solemnly swear affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications? So if you got under the penalty of perjury. Okay. All right. Just let me know if I get going a little fast. All right. All right. So we are on the record in docket 26-01788. That is People of the State of Michigan versus John Luxon. All right, appearances for the record, Ms. Flynn.
Gabrielle Flynn, Assistant Prosecutor for the people.
Ms. Rawls.
Assistant Public Defender Linda Rawls, appearing on behalf of John Luxon, who's present in court to my right.
And sir, you are John Kelly Luxon. All right, this is the time set for final pretrial in the matter. Ms. Flynn, how are we proceeding?
Thank you, Your Honor. At this time, the people's necessary witnesses have failed to appear. We did have proper contact with them. They did indicate that they were going to be here. Subpoenas were sent. However, the victim did indicate she did not receive her subpoena, but again confirmed she would be here. And she is not. At this time, Your Honor, we do expect a motion from the defense.
Ms. Rawls.
Thank you, Your Honor. Given that the victim has failed to appear, the defense moves to dismiss.
All right, this was set for pretrial on, looks like July 20th. And then that on that date, we set it for final pretrial. And it was set on August 3rd at 8:30. It's now August 3rd at 9:25. And the people are unable to proceed with the final pretrial because they've had some contact with the victim. She said she was going to be here, and it's my understanding is she's not here right now. Is that correct, Ms. Flynn?
That is correct.
So I'm going to grant the defendant's motion to dismiss. As Ms. Flynn has indicated, there's been some contact with the victim, and the victim indicated that she was going to be here and is not. We're into it. I do have, so I'm in possession of the order of acquittal. There is a no contact order, but there is not a GPS. So I'm going to sign the order of acquittal. So Mr. Luxon should keep a copy of the dismissal because it takes about 4 hours to purge this from the computer system. So this is dismissed without prejudice, which means that people could reissue if they choose to after they reevaluate the case. Right. And you should keep a copy of the dismissal with you. Anything else for the record in docket 26-01788, Ms. Flynn?
Not for the people, thank you.
Ms. Rawls?
Nothing from the defense, Your Honor.
All right, Mr. Luxon, we'll provide a courtesy copy and you should be all set. And thank you for your assistance today. All right, Ms. Flynn, who are we calling next?
I believe we are ready on Mr. Molitor's case.
On Dominic Molitor. All right, so we're on the record in docket 26-01817. That is people of the state of Michigan versus Dominic Molitor. Appearances for the record, Ms. Flynn.
Thank you, Your Honor. Gabrielle Flynn, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Dominic Molitor, who is standing to my right. Mr. Molitor, if you could please state your first and last name for the record.
Dominic Molitor.
All right, thank you. This is the time set for a final pretrial in the matter. Ms. Flynn, how are we proceeding?
Thank you, Your Honor. At this time, the people's necessary witness has failed to appear. We did have successful contact with her in a way. She did indicate to us that she did not want to appear today. I reminded her of her subpoena that she did confirm that she received it, but Your Honor, she is not here today. I do believe there will be a motion from the defense.
That is correct, Your Honor. Given the complaining witness is not here today and it's indicated they're not interested in proceeding, I would make a motion to dismiss at this time and would request that a copy of the motion, if granted, be provided to my client.
So as Ms. Izell indicated, Ms. Flynn indicated, the complaining victim was subpoenaed and has failed to appear. This is scheduled for 8:30. It's now 9:29. Any contact's been unsuccessful, and you actually spoke to the victim.
Correct, Your Honor.
Okay. So so the people are unable to proceed. I'm going to grant the motion to dismiss. To dismiss without prejudice. Thank you, Susie. All right, so this is dismissed without prejudice based on the defendant's motion. I have a no contact order. There is no GPS order. This is dismissed without prejudice, which means that this could be reissued if it's reevaluated by the prosecutor's office. But for our purposes today, the case is dismissed. All right, sir. And the no contact order, it'll probably take about 4 hours to purge from the computer system, so you should keep a copy with you. All right. All right. Anything else for the record in 26-01817, Ms. Flynn?
Not for the people.
Mr. Harris.
Looking from the defense, Your Honor.
All right, you should keep a copy. We'll provide a courtesy copy. You're all set. Thank you for your appearance, Mr. Molitor. And then Mr. Decker.
Oh, Devin Ornelas.
Okay. All right, so we're on the record in docket 26-01772. That is people of the state of Michigan versus Devin J. Ornelas. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people, pressing pursuant to MCR 8.120 under direct supervision of APA Gabrielle Flynn.
All right, thank you. The motion's granted, and you only have to make that motion one time today. All right, Ms. Rawls.
Assistant Public Defender Linda Rawls appearing on behalf of Devin Ornelas, who's present in court, standing to my right.
And sir, you are Devin Ornelas, is that correct? All right, thank you. This is the time set for a final pretrial in the matter. Mr. Decker, how are we proceeding?
At this time, we expect a motion from the defense as we have subpoenaed the victim and attempted to contact her, but have been unable to have any contact with her whatsoever. And she is not at court today.
So the victim was subpoenaed for the final pretrial today and has failed to appear. You've had no contact with her, is that correct?
Yes, Your Honor.
Ms. Rawls, you have a motion.
Yes, Your Honor. Given that the victim has failed to appear, defense moves to dismiss.
Right, I'm going to grant the motion to dismiss without prejudice. And I'll have it printed out. Thank you, Susan. So on docket 26-01772, the complaining victim was subpoenaed, has failed to appear. This was scheduled for 8:30. It's now 9:33. I don't have a GPS, but I do have a no contact with the complaining victim. So, so at the request of defense, I am dismissing without prejudice, which means that people could reissue, but for our purpose today, the case is dismissed. And you should keep a copy of the dismissal with you because it takes about 4 hours to purge from the computer system. And I'm signing the order of dismissal. Anything else for the record in 2601-772, Mr. Decker?
Not from the people, Your Honor.
Ms. Rawls?
Nothing from the defense, Your Honor.
All right, we'll provide a courtesy copy for you to keep on your person. That's all for the record in 2601-772. And then, Ms. Flint, you let me know if you need a break to talk to witnesses or anything. I think I've got McLeod and Trowbridge left.
And that's what I have left. I think I'm prepared to go on McLeod. Our witness is here. We already spoke to her. But it appears Mr. McLeod is not here.
All right, so let's go on. So let's call McLeod because we're an hour into it. So Ms. Rawls, I think that's yours. All right.
And I was just trying to double check that he's not in custody in a different county or anything.
Let's see. Are they in the waiting room? Let's identify them. On REVVL 8, could you please identify yourself on REVVL 8? Right now, I've got a picture of what looks like a bathroom, a shower. REVVL 8. All right, let's call McLeod's case. I'm not getting any response from. All right, so we're on the record in docket 2601-752. That is People of the State of Michigan versus Tavion McLeod. Appearances for the record. Ms. Flynn.
Thank you, Your Honor. Good morning, Gabrielle Flynn, Assistant Prosecutor for the People.
All right, Ms. Rawls.
Assistant Public Defender Linda Rawls, appearing on behalf of Tavion McLeod.
All right. And on REVVLE 8, what's your name, ma'am or sir?
Gwen Johnson.
Gwen Johnson. Oh, Gwen Johnson, you're here for your 9 o'clock, ma'am?
Yes.
All right. All right, you're in the right place. We're going to have you renamed. And then let me identify the post. So Ingham Jail Post 1 of Visit 5. Out of the incarcerated individuals, if you could please identify yourselves. Is there a Ryan Duchette? All right. Is there a Ronnie Trevino? All right. And is there a Jack Reed? All right. You've all been identified. So this was set for 8:30. It is now 9:37. I do not see the defendant, Tavion McLeod, in the Zoom courtroom. Is there anybody in the physical courtroom? And sir, on the Motorola Moto G, could you please identify yourself? You'll have to unmute. You're on mute right now. What's your name, sir? Sir, what's your name?
Timothy Trowbridge.
Okay, Timothy Edwards.
Trowbridge.
Oh, Trowbridge. Okay, so Mr. Trowbridge is here. Okay, he's on Zoom. All right, we've identified you, and we'll place your case on the record. Okay, man. Okay, sir.
Yes.
All right, so I've identified everybody in the Zoom courtroom and physical courtroom. And we'll call the hallway for for Mr. McLeod. It would appear that Mr. McLeod has failed to appear today for the final pretrial. Usually in these cases, we do these in person, but I've just doubled kind of a belt and suspenders thing. So it appears that Tavion McCloud has failed to appear for the final pretrial. Ms. Flynn, how did you want to proceed?
Thank you, Your Honor. At this time, the people's necessary witnesses are here and we were ready to proceed today. So at this time, we would be asking for a bench warrant to be issued.
All right, response, Ms. Rawls, has your office had any contact with Mr. McLeod?
We have had contact with Mr. McLeod, but that was for the pretrial.
Okay. All right, because of the nature of the offense, it's a domestic assault. I'm gonna issue, and Mr. McLeod has appeared to fail to appear. I'm gonna issue a bench warrant, an immediate bench warrant for his failed to appear. We are ready to, the witnesses are here. And so we'll issue an immediate bench warrant for his failed to appear today. Anything else for the record in 26-01752, Mrs. L.
Not
Or
for
Ms.
the-
Flynn?
Not for the people, thank you.
It's gonna take me some time, okay?
That's fine.
Miss Rawls.
Nothing from the defense. Your Honor.
All right, for the failed to appear today for the final pretrial, the court has issued a bench warrant. And that should be all on that. And then Mrs. L, did you want to meet, or Miss Flynn, did you want to meet with Mr. Trowbridge, or do you just want to put it on the record?
I think we could just put it on the record, Your Honor.
All right, Mr. Trowbridge, and
Yes.
can I call those together?
Yes, Your Honor.
All right. All right, so we're on the record in 26-01500 and 26-01501. That's People of the State of Michigan versus Timothy Trowbridge. Appearances for the record, Ms. Flynn.
Thank you, Your Honor. Good morning, Gabrielle Flynn, Assistant Prosecutor for the people.
And sir, you are Timothy Trowbridge, is that correct?
Yes.
All right, this is the time set for a final pretrial today. Ms. Flynn, how are we proceeding?
Your Honor, at this time, due to the nature of the case, we usually don't ask animal control to come in to show that they're on board for this. I will just go ahead and re-extend on the record and offer here, if Mr. Trowbridge has not received this before, I will give it to him for the first time here. If we can have a showing of any sort of proof that the dogs are now contained and are able to be under the control of Mr. Trowbridge, or if there's any indication that the dogs have now been rehomed, we would go ahead and dismiss for compliance. At this time, we do not have that. We would be willing to adjourn today's date for that purpose.
Mr. Trowbridge, what is your request today at this final pretrial?
A request, being innocent. And the dogs just got out the door and went next door, and that's about it. So.
All right, I'm gonna indicate, don't say anything that I could be used, that could be used against you, because you agree with me, you're not represented by counsel, is that correct?
Yes, sir.
All right. Should we adjourn for a second final pretrial?
I would ask for that, Your Honor. I would also ask if the court would potentially do an inquiry on whether Mr. Trowbridge would like an attorney.
Yeah, Mr. Trowbridge, this is punishable by, both counts are punishable by at least 90 days and or 100. I think it's $100. So did you want a lawyer today, sir?
No, sir.
All right. So so this is punishable by 90 days. I'm going to adjourn for a second final pretrial, and at some time before this, you should probably contact the prosecutor's office to make arrangements to negotiate something concerning this matter, if you choose to. All right, sir?
Yes, sir.
All right. So we'll adjourn for a second final pretrial. For August 17th at 8:30. All right, so I've adjourned this to August 17th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. All right, Mr. Trowbridge? So Zoom would be inappropriate for that final pretrial.
Okay, I understand.
All right. So it's a live in person on August 17th at 8:30. The parties can talk before then, but at least we'll have Mr. Trowbridge here and we can go from there. Okay. Anything else for the record in docket 26, two dockets, 26-01500 and 26-01501, Ms. Flynn.
Just your honor, I would like to add that it does appear that Mr. Trowbridge may be diversion eligible, so we will be looking into that and hopefully we can contact him about that
All right.
possibility.
All right, Mr. Trowbridge, do you have any questions of me? That'll be live in person on August 17th at 8:30. And in the meantime, if you want to contact the prosecutor's office, that would be all right. You are not represented by counsel.
Yes, correct.
All right. All right. All right. I'll adjourn that to August 17th at 8:30. Thank you for your appearance. You're all set, Mr. Trowbridge.
Thank you, Your Honor.
And do you want to go, Mr. Rogers?
Yeah, please.
All right, so we're on the record in docket 25-03484. That is people of the state of Michigan versus Robert Rogers. Appearances for the record, Ms. Flynn.
Thank you, your honor, and good morning. Gabrielle Flynn, assistant prosecutor for the people.
Ms. Donnelly.
Good morning, Assistant Public Defender Sarah Donnelly, on behalf of the defendant Robert Rogers, who is standing to my right.
And sir, you are Robert Rogers, is that
Yes, I
correct?
am, Your Honor.
All right, thank you. This time is set for a PA 53 violation. And Mr. Rogers, all we're doing right now is we're waiting to hear from forensic, okay, concerning this
I
matter.
wanted to bring up a little matter to you. My neighbor, Andy and Tom at Own Playmaker, said that you can have the video camera, the cop there. They trespassed my property and stole the phones.
Yeah,
And that's just something that's obstructing justice. They stole my phones with records and I sent you guys that email.
right,
That's from Mike Gankowski from Michigan State University.
right.
He threatened if I called the police, because I was supposed to talk to Zanetta. The president of MSU told Zanetta to call me and call her back if I had issues, and I called her back, and Mike Gankowski threatened me with that message.
All right.
So that's what that is. That's obstructing justice, and you know that.
All right. Right now, there's the people would have to prove any case against you. Okay?
Right, they haven't proved nothing. I'm not, right, yeah.
We're
So
waiting to hear from forensic for.
my big thing is obstructing justice and then breaking in my house and stealing it, and they hit my dog in the head and left a big welt on him. That's cruelty to an animal. And I just wanted to bring that to you for your own heart
Okay.
to think what's going on here. There's some criminal activity, and I give Sarah a lot of evidence, and she goes, there's HIPAA violations involved.
Right.
And Mike and Rick Grillo's got all that. And he even has the same email you got. And one of their police officers, I'm not taking a police report on another cop doing a crime.
All right.
So that's obstructing justice, and you know that. They're supposed to look into that as, no matter if you're a police officer, a politician, or a human being, if you do a crime, you're supposed to investigate it.
What?
So that's all I brought to you.
All right,
Attention.
and that's fair. Right now, we want to see what we have an order out, and we want to see if they're going to follow up on the order.
Right.
And for whatever reason, I'm not sure if they're following up on the order.
I don't
but-
think they're following up on the
But
bill of
we're
choice.
going to get an answer from them.
Yes.
Yeah.
So we've set this for September 14th. I'm going to adjourn the PA 53 violation.
What's that PA 53
It's a
violation?
no contact order
Okay,
violation.
okay.
And that's what, there's an indication, but I'm not doing anything until we get some competency, you know.
Yeah, that's fine. And my biggest part, I want honesty and truthfully, like I said, Your Honor. And if they changed my forensics from the first time, that's a criminal act. You know that. So I just want to bring it up. And the prosecutor knows when I got Stuart Dunnings fired, there was a pandering charge there that was a 20-year sentence, and he loses $4,000 a month. So how did they get rid of that? But they put a stalking charge on me to cover all this up. There's something weird going on there. Sarah knows there's something going on here too.
All
So
right.
I just wanted to bring it to the court's attention. The prosecutor's office should contact me because Scott Hughes over there, he's got all the information on his cell phone. So you guys might want to look at Scott Hughes' cell phone. there's evidence on there of obstructing justice too, okay? So you
Right.
guys want to bring that up to the case? Evidence that's on Scott Hughes' phone, and I do have record of all the information on this cell phone right here, even though they stole off my phone,
All right.
okay?
The hearing's been set for September 14th at 1:30. I think one of the things is we want to know why you're not being re-interviewed, okay? And so that's.
Why is the truth not coming
Right,
out?
so,
What I asked,
yeah,
yes.
and so, before we can do anything else, we need that.
Here's the one thing I would ask for a motion. I would like to bring, even in front of the prosecution, Sarah and everybody in the courtroom, I want Dolores Zarka brought in for testimony.
All right,
She worked at 54A District Court, and she come to me when they pulled the fire alarm, stole the forensics, and that's a crime.
okay,
So I want that, and that's all involved in the same situation. Dolores Zarka, subpoena her to court. And I
All
want
right.
Sarah to know that, and I wanted to bring it to your attention so nobody can hide that.
all right. Nobody can hide anything.
Okay.
What we really need to do is,
Well, that's the full
Is-
truth
is-
of that testimony
Right.
and evidence of somebody obstructing justice.
all right,
Okay, so you ought to want to step foot onto that and say, what's going on here? We ought to have an investigation on this. And I asked for Sarah to put a motion in for an investigation.
and you,
Does that sound fair?
yeah,
You
yeah.
represent me, you should,
Yeah.
when I ask you to,
But
for an
this-
investigation,
This
you
is
should
a
be able
whole
to submit that.
different
Right.
matter concerning this.
But that's a
but-
big thing that's going on here. You
Yeah,
can't
so
cover
we'll
up
have
a
to-
crime with a crime, and you can't create a crime with a nothing.
And you're still on GPS tethers, actually.
Yeah, I shouldn't be, but yes, I haven't gone near this guy, and I'd like it on me because that proves that I'm not going near him.
Absolutely.
Thank you.
It's there for your protection.
It is. Thank you for that. And here's the deal. Can we find out if somebody tracks me with this and comes to my house when I leave? Because I went to Park Lake Road and I had to do a U-turn because I see the cop at Crest
It
Hill.
wouldn't be law
And I
enforcement,
seen that law enforcement in my
right?
It
house.
could be.
It could be used. So
Meridian-
I would like to know if Meridian Township can pull my, or any police officer
Meridian
to
Township
harass me.
could be investigating, yes.
Yes.
Things.
Yeah, I
So
have no
if they're,
idea.
if they're investigating the HIPAA violations, they don't care where I'm at. They're
I just don't
investigating
know
the
what
doctor.
Meridian Township is.
But
doing.
I'm not.
And here's another thing on the police report. You told me to follow up on it. And you told us both that. They are not following up on it. They tried changing the police report number and they tried throwing it away.
Okay,
And I have the recordings of that on the phone.
Okay.
And right now dispatch, Andy that runs dispatch is investigating with the Ingham County Sheriff, my phone calls, so they know who threatened me and what's on them, okay?
all right.
So I want you to know that dispatch is doing that.
And that would be a different. the Ingham
Well, it's all
County
on
would be-
the, it's all on the,
All right.
all, they wanted to know about my competency. That's what they asked me, and I says, here's the competency, pull my phone records up and they'll tell you the truth of everything on it. And that's honesty, okay? So I'm not doing anything illegal, you know that, and I give you all my love to this courtroom because I want you to be honest and I want you to know the truth, okay? And that's fair, isn't it?
It's
For me,
ve-
you
very
can know the
fair,
truth, yes.
Very fair.
And I want to know the truth as much as you, so.
And the first thing we got to do is find out why forensics is not acting on the order.
Yes, and you know, Judge Felice did order forensics with cranial attachment,
Right.
and that is a positive thing. No, my cranial attachment's fractured, you know
No,
that,
he, from
But,
the accident.
yeah, but
from my
that-
accident, right?
Judge Felice hasn't been on the bench.
No, I know it, he hasn't, but they covered that up when, and Dolores was here when they pulled the fire alarm, so
Yep.
Dolores is my witness, and she even knows they come into her courtroom. Out of the courtroom, they come in Dolores Zarka's room, and they told her right up that they had to pull the fire alarm to steal the forensics. They put a bag of popcorn in the microwave.
All right.
And that is true facts that she told me. And she was a court officer that worked in the courts.
All right. Currently on GPS, we're adjourning the PA 53 violation and we've set it for September 15th at 1:30, and then we'll contact.
14th or 15th.
Your Honor, if
That's
you
good.
need the
That's a
subpoena from
Good
the,
question.
hey, if you need subpoena from next door though, they do have that film, okay? And that's a big thing. I'd like to bring the proof to all of the court. Evidence, and I do have all the evidence.
September 14th.
Yes.
All right.
So can you do an investigation on that court paperwork from the courts?
Yeah, we're just gonna go one at a time.
Right, but I would like you to pull that court
Right.
paperwork up.
Right.
And you know, that was all dismissed from Joe C. Bueller. And he had removed from Lansing. They made him be an aviation attorney now.
Yeah, I don't.
They sent him from here and that was all dismissed from, wasn't it?
All
It's
right.
all in Tremblay's office.
Okay.
So it's September 14th at 1:30 is
1:30.
back, and then
Yep.
we'll provide. You're still on GPS.
Yeah, that's fine.
No.
Like
and
you
then-
said, that's to protect me and I thank you
Yes,
for that.
Yes, and then we'll find out what they're doing in regards to the order.
Okay.
Okay.
Let me ask you one thing. It's
Okay.
been so hot where I work. I mean, I've had trees bust me in the legs and have bruised my leg up from this thing. And another thing, when I'm done at 100-degree day cutting trees and stuff, and I shouldn't be doing nothing, you know that.
Right.
I should be able to get in a swimming pool and cool off. And I can't with this. They told me, no, you get shocked.
Probably
So,
get
I mean,
shocked.
I'd like that being on me. And if I was gonna get in the pool, I would ask them if I could take it off. I'd put it right back on me. You know what I'm saying?
I just
That's
wanna
for
make
my,
sure-
my health of my life.
Yeah.
Right.
because-
And I am being protected with that. I thank
Yeah,
you. Thank
yeah,
you.
that keeps you from being arrested for something you didn't do.
Right. I appreciate
And
you
Your
on
Honor,
that. Thank
did
you.
you want to, because the allegation is that you violated no contact order. I think Judge wanted to warn you about the no contact. order.
There, I've been contacted. I'm trying to.
I think the GPS would suffice for that.
Yes.
All
Yeah.
right.
All right. Anything else for the record in docket 25?
Okay, one more thing. This guy supposedly moved. Where did he move to where I'm not allowed to be? I gotta have a location where I can't be.
As long as they know where you are,
They're fine.
Yeah, they're fine.
Thank you.
They're
fine.
That's what I want
Yeah,
to make sure is true,
No,
because they can't say that I was near his house. I don't even know where he lives.
right,
Yeah.
right.
Thank you.
You can't be in exclusion zone where you don't.
Exactly.
That's
think
not, and I
that's a
pushed
fair
that.
statement.
I pushed that. So really, they shouldn't be saying, oh, you're in the wrong area. I don't even know where I'm supposed to be there.
Right.
Thank you.
Exactly.
Triple hernia, look. Triple hernia. I can't even go into doctors because this guy comes and shows up.
If you need medical treatment, get medical treatment.
Where can I go then? Where I feel safe, where this doctor don't show up there?
I don't.
Can you guarantee I go to the hospital and he don't show up?
I
want to ask that. Do I
He's the
feel
only-
safe in a hospital with this Dr. Holberg showing up?
I
It's
don't
very
know.
clear,
I don't-
Mr.
I don't, that's why I said,
You
do I
did-
have to leave the state? Because
Mr.
I'll have to
Rogers,
get with you.
Mr.
No.
Rogers.
I wanna
he-
ask.
If you
I
want
wanna
to
ask.
answer, then let him answer.
Okay.
Only the victim can contact, and so you should be fine to get medical treatment. Okay.
So
Yeah,
can we make sure if he comes in a hospital I'm at, like Okemos, am I even allowed there? Because Amber McKnight over at Meridian, or at U of M says, you better not go to that hospital because they'll do something to you.
I don't know what she said or what she told you. What I'm saying is if you need medical treatment, you should be able to get medical treatment.
Can I call your court appointment if I have a doctor's appointment in another town or another state and ask for that permission?
And the only criteria
I'd call
is,
Miss
Mr.
Donlin
Rogers,
first.
is that if you do see this guy, you're supposed to turn around and leave.
Yeah, that's the
Right.
only.
I
he's
mean,
the
when
only
I'm in
one
a doctor's
that-
office, he's got to cross 3 of them to get to mine.
Right.
That's not right.
Right.
You know that.
Yeah.
Right.
Thank you.
Yeah.
Anything
You-
else, Miss Flynn?
No, Your Honor.
Miss Donnelly?
No, thank you.
You should be all set, Miss.
You
Rogers.
have a beautiful
All right,
day.
you
Thank
too.
you.
Thank you.
All right. I got it.
All right. Mr. Harry's Mr. Trowbridge, and Miss Flynn, you'd let us know. And Mr. Decker, you let us know if you need a break, okay? All right.
Comedy shows.
Yeah.
Mr. Harris, there's several people here from the jail and then,
Which one? Sorry. Yeah. Okay.
so Ms. Rawls, did you need to speak with anybody?
Yes, Your Honor, I need to speak with Reed and Janino. I will log in.
All right. So once you join, I can place you both in a room, okay? So Mr. Trevino, I'm gonna put you, so you can raise your hand, sir, just to make sure I've got the, it is Ronnie Trevino.
I think it was a dog. I think Cassidy may have said it was possibly.
In one of the posts, one of the incarcerated posts, can you raise your hand, Ronnie Trevino?
In consideration.
All right. I'm gonna place you with your public defender and then we'll come back and put your pretrial on the record. All right, sir? Post 1-6. Let's put him, let's B231. So I'm gonna assign you to room 1
Falcon, kind of like they're outside.
and then I'll put Miss Rawls in the same room.
Also have a new leash they can use for the dog, so that should. hopefully
What about
resolve.
harness or collar, you know? I know that's a weird.
Yeah, I don't know. try and talk to her about that. I have
But
to
you
try and-
know that that was the color.
Yeah, I appreciate the color, because I can't imagine what they're connecting the leash to other.
Well, and that's why I asked, because we have a picture of a leash on the ground. Like, that doesn't tell me that
Well, yeah,
they
I
have a
think-
way to connect.
I've never
Yeah,
heard
I
that part
think
of
the
the
reason
story
is just
yet,
that
so.
Oh, there's a lot of all these
I know
stories.
all the
Can you,
original
can
stuff,
you
because
just
I
take
worked with
pictures so I
Dolores.
can try and get them
So,
fast?
okay, yep,
I'm
let me
not
just
sure.
double check, because I'm pretty sure there was no.
I don't know.
But you handled that so well.
On Briteria's iPhone, could you please identify yourself? And you'll have to unmute on Briteria's iPhone. Are you Briteria Hill, ma'am? Or sir?
Yes, I'm Briteria Hill.
All right, all right. You're here for your 10 o'clock?
Yes.
Right, you're in the right place. Stand by, okay, ma'am?
Alrighty.
All right.
There's two dogs, one I can't remember the name of, the other one's named Martin, like. The other dog was surrendered. She's still back.
So what case do you want to go, or do you want to take a break?
We could just have a brief break.
All
and
right.
we can get some
All
things
right.
wrapped up.
All right, so let's take about 10 and they'll come back. Oh, here's Mr. Halls. And we're gonna put her in with Mr. Trevine. Let's admit. Assign to room 1. There we go. All right.
All right.
Yeah, but Cass used some proof, which is when I messaged her about getting pictures.
Maybe see
Did you forget about me?
Awesome dirty woman drinking. I think he was bad, bro. The prosecutor almost said she. And they suck at the job.
9. Yeah, they have me on mute right now. Pay attention to that dang phone. So, look at it, video. I mean, you're not on mute anymore. No. Oh, yeah. This way. Where are you going? Ugh. I've been on here since 10 to 9.
Thank you. Stop. Man. There's my first year day time. Other counties do not release night master day. He may be PFI machine. Kingdom County, Doors County. To this so. Peace. Oh, they're taking breaks. I can't even leave the room. You all might as well just start deep. Cheap eyes. I'm down there for the Miss Lunch being here. nigga's cheap. Here you go. I'm gonna tell me.
Huh? Should have done that when she woke me up. Oh, why didn't you do it at 8?
Put your phone, bro. You almost really lame TV version. Regular shit. I don't know what the fuck y'all going from this, bro. And they're gonna say, fuck it, and just tell them I'm done with the work. Walk out to the bitch, I ain't gonna lie. Other shit. Irritating me.
Ridiculous. I got on at 10 to 9. My appointment's at 9, and they're doing 10 o'clock. That's all right. I know. It's ridiculous. Sorry.
Yeah, these guys, they keep on doing the whole. I'm tired of this shit, bro.
They say 10-minute break, but then they're gone for half an hour.
Cause got niggas in this bitch looking dumb as hell. Get a dumbass prosecutor. Cause just kept this shit going. What are you all doing again? Especially all that dollar bill, though. Ain't care. My also mother, she's 10:30, bro. I was supposed to be back. I was supposed to go to my class and everything. No, I can't. So I mean her. Yeah. Yeah, my people coming in for leave and shit.
Sir, you are Ryan Duche, is that correct?
Ryan Doucette, yes, Your Honor.
Okay, Ryan Doucette, thank you. And you can hear me all right, Mr. Doucette?
I can hear you fine.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Decker, how are we proceeding?
It's my understanding we'll be moving for a final pretrial, Your Honor.
And is that your understanding, Mr. Harris?
That is correct, Your Honor. I have spoken with Mr. Doucette previously regarding this matter and our options. At this point in time, we would be requesting a final pretrial court date.
All right, we'll set it for final pretrial on August 31st at 8:30. All right, we've set this final pretrial for August 31st at 8:30. Anything else for the record in 2500218, Mr. Decker?
Nothing from the people.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. Doucette, we'll see you on August 31st at 8:30. Thank you for your appearance today. You should be all set.
Okay, thank you.
Where are we heading next, Mr. Decker?
Here. Your Honor, if we could move to Anita Johns, please.
Anita Johns.
Yes, Your Honor.
All right, Ms. Johns, you can unmute and we'll call your case. So we're on the record, and can I call those cases together, Ms. Flynn?
Yes, Your Honor.
Yes.
All right, we're on the record in 26-01629 and 26-01630. Appearances for the record, Ms. Flynn.
Thank you, Your Honor. Good morning, Gabrielle Flynn, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Anita Johns, who appears via Zoom, Your Honor. Ms. Johns, if you could please state your first and last name for the record.
Anita Johns.
All right, thank you. And you can hear me all right, Ms. Johns?
Yes, I can. Thank you.
All right, this is the time set for a pretrial on these two cases. Ms. Flynn, how are we proceeding?
Thank you, Your Honor. At this time, we believe we have come to a resolution in the case. The people are offering for Ms. Johns to plead to 1 count dog at large. Upon proper plea to that 1 count of dog at large, the people would be agreeing to dismiss the count 2 dog at large or the second case. And additionally, we would be agreeing to not issue the 3 dog at large cases pending with our office, none of which have restitution involved, Your Honor.
All right, and is there are we going to immediate sentencing, or did you want this referred to probation? Either one's fine.
We would be okay with immediate sentencing, Your
Alright.
Honor. I believe the people would be agreeing to fines and costs in this case.
All right.
That is a correct statement of the offer, Your Honor. I have spoken with Ms. Johns, and at this point in time, she is wanting to accept that offer.
All right. And which file will she be pleading to, 2-9 or 3-0?
Can we please do the 3-0? case?
Yeah. All right. All right, and that's a fair statement, Mr. Carries. She'll be pleading to 26-01630. There's an agreement of fines and costs. We're going to immediate sentencing, and we'll dismiss 26-01626 as part of the agreement.
That is correct, Your Honor.
Mr. Harries may inquire of Ms. Johns of her jury trial rights.
You may, Your Honor.
All right. And Ms. Johns, is that your understanding? You'll be pleading to one count of dog at large, and we'll be dismissing the other count of dog at large, and then we'll go to immediate sentencing. Is that your understanding, ma'am?
Yes, Your Honor.
All right. All right. Ms. Johns, you have the following jury trial rights concerning this 26-01630 plea, and I'm going to walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to questioning witnesses that are brought against you. You're represented today by Attorney James Harries, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, I do.
You have the right to have the court order any witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we placed on the record or threats it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from a trial, since you won't be having a trial. You'll be pleading guilty to the misdemeanor 26-01630 dog at large case. Is it still your wish today to plead guilty to the misdemeanor dog at large case?
Yes, Your Honor.
All right, Ms. Johns, I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, I'm going to bring your attention back to, let's see, June 16th, 2026. And what is the name of the dog that is this one or Tiny?
One, Your Honor.
One.
Previously surrendered to him.
All right. And you were in charge of one concerning the behavior of one. What type of dog is that, ma'am?
He is he's a mixed breed, Your Honor.
Okay. All right. And on June 16, 2026 at 5632 Hughes Road in the city of Lansing, one was under your supervision and was the dog at large on that date. Is that correct?
That is correct, yes.
All right. Anything towards a factual basis, Ms. Flynn?
No, Your Honor, thank you.
Mr. Harries?
Nothing from the defense, Your
All
Honor.
right. I find the factual basis to be knowing, voluntarily, and accurately made. And we can go to immediate sentencing on this file. Anything towards allocution, Ms. Flynn?
No, Your Honor, thank you.
Mr. Harries, do you want to be heard on allocution?
Your Honor, Ms. Johns is apologetic for this. She has tried to take some manner of compliance. There is a leash they have, a better leash they have for the dog now. Additionally, they are currently staying in a second floor apartment where the only access to the outside is a balcony, a fenced in balcony with a pretty high fence. So I believe it's less likely that the dog would be able to get out now that they've moved. I don't believe this is likely to happen again. I would simply request that the court follow the agreement regarding fines and costs in this matter. Miss Johns has been going through a bit of financial hardship lately and does qualify for the Aiken County Public Defender's Office due to being indigent. I would ask if the court would consider minimal fines and costs and give her 90 days to pay that.
All right, and what are fines and costs on? It's 90 days and or, I don't know what the fines and costs
I
are.
believe it's $500, Your
Yeah, I
Honor.
believe it's up to $500.
Correct.
Okay, 90 days. Ms. Johns, is there anything you'd like to say to the court before the court passes sentence?
Just that I am sincerely apologetic, and I do realize I have realized my responsibilities when it comes to our animals and keeping them safe. And we have gone to great lengths to ensure that we are able to do that. I do appreciate everyone's time and for being patient and for working with me. Thank you, Your Honor.
All right, thank you, Ms. Johns.
Yeah.
So we will go to immediate sentencing. I'm going to set fines at $50, costs at $50, crime victims' rights fee of $75, and I'll waive the state fee. So that's a grand total of $175 to the city of Lansing. And Mr. Harris, you indicated your client needs 90 days. Is that correct?
That is correct, Your Honor.
So 90 days out would be November 1st. All right, so we'll set $175 to the city of Lansing by November 1st, 2026. Ma'am, that can be paid online, in person, or by phone. And the beauty of the November 1st date is you can make your own payment plan up to November 1st when it's all due. All right, ma'am?
All right. Thank you. Yes, Your Honor.
All right. And upon successful plea and sentencing, 2601-629 is dismissed. Anything else for the record on either one of these files, Ms. Flynn?
Not for the people. Thank you.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Ms. Johns, you're all set. Thank you for your appearance today.
Thank you so much, Your Honor. You have a wonderful day.
And what file are we calling next, Ms. Flynn?
I realized we should probably go to McLeod. I forgot that we were.
All right, so let's go on Tavion McLeod. We're on the record in docket 2601752. That is people of the state of Michigan versus Tavion McLeod. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Flynn, Assistant Prosecutor for the people.
Or Ms. Flynn.
Okay.
It's gonna take some time. Ms. Rawls.
Assistant Public Defender Linda Rawls appearing on behalf of Tavion McLeod, who's present in court.
And sir, you are Tavion McLeod, is that correct? Yes, sir. Okay. This was the time set for, actually, I was gonna sign a bench warrant. That you failed to appear previously. Your case was at 8:30. I don't know what time you showed up. We called this about 9:37. So with the witnesses were here at one point in time and they failed to appear. Mrs. L, how did you want to proceed?
Your Honor, at this time, I think the people would be of the stance that we just move this to a jury trial.
Okay, Ms. Rawls. Is that your understanding?
Well, I've had an opportunity to talk to Mr. McLeod, and he's prepared to enter a plea.
The people would be willing to accept a plea in this case, Your Honor.
All right, a plea to what?
No contest to the, I think it's the domestic violence charge.
All right, and what are we using as a factual basis for the plea?
The police report.
Okay. And is that your understanding, Mrs. L, that the defendant would be pleading no contest at this time? And I know you haven't talked to the victims in this case.
Correct, Your Honor. It was not my understanding that there would be a no contest plea in this. I would ask what the basis for the no contest would be at this time.
what I'd most likely do is set this for plea, you know, but, and then we can address bond. So we'll, because that gives Ms. Rawls the opportunity to send you the no contest plea and then to send it to us, and then, so we'll set for plea. And it will be in the nature of the no contest, but we can set for plea when? August 17th. At 1:30. And that should allow Mrs. L or Ms. Flynn, that should allow you to have some time to talk to the complaining victims in the case. We've set it for August 17th at 1:30. And now we're going to address bond. Ms. Flynn, how should we address bond? Bond is set at a PR bond at this time.
Your Honor, the people would ask for an increase in bond at this point, as there was pretty much a failure to appear today. The people were ready to proceed. We had our victims ready to go. We would ask that there be some security that the defendant appear for his next court date.
Thank you. Ms. Rawls' response.
Your Honor, it looks like the defendant just overslept, unfortunately. He's actually still in his pajamas. He did appear, and so we would ask that the court continue the bond. I think there's some assurances that he's also on tether. I think there's some assurances that Mr. McLeod will show up for his plea. He's willing to accept responsibility for his actions, Your Honor. So we just ask that the court will continue.
Mr. McLeod, anything you'd like to say to the court before the court modifies your bond?
Yes, I do want to say, I do apologize for oversleeping. I meant to get here as soon as possible. But
8:30 would be good.
Yeah, no, it would. Every other court day, you know, I showed up to him. Like, and I promise I won't miss the next one. And I'm on tether, so.
All right, well, I'm going to modify the bond because the defendant was not here and we had witnesses here. So the bond is modified and it was set at a PR bond, 500 PR. I'm going to set it 300 cash surety. And Mr. McLeod, you can go with DK with the security, and your bond is set at 300 cash surety.
All right. Would I be able to pay that right now?
I think they have to process you in, and then you're going to be given the opportunity by LPD to pay the bond. Okay. All right. You should be all set, sir. Thank you for your appearance. Miss Flynn, who did you want to call next?
Your Honor, if you could just give us 1 second here.
And then you do have, there's some people on. Hill.
We would be ready to go on Gwen Johnson, Your Honor.
All right, Gwen Johnson. Two, three. Okay. All right, so we're on the record in dockets 26-00137, 26-00138, and 26-00139. That is people of the state of Michigan versus Gwen Johnson. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Ms. Raw.
Assistant Public Defender Linda Rawls, appearing on behalf of Gwen Johnson, who is available via Zoom.
And ma'am, you are Gwen Johnson, is that correct?
Yes, that's correct.
Right, and you can hear me all right, Ms. Johnson?
I sure can.
All right, thank you. This time set for pretrial on these matters. Mr. Decker, how are we proceeding?
The people would be moving for dismissal this time as we've been shown proof of compliance.
And is that a fair statement, Ms. Rawls? I'm assuming you have no objection.
I have no objection, Your Honor. That's a fair statement. Your
All
Honor.
right. So this would be a dismissal for compliance. So all these are, and I believe these are all on a ticket. Let's see. All right, so 26-00137 is dismissed without prejudice. Twenty-six zero zero 138 is dismissed without prejudice. And 26-00139. And all these are written on the same ticket, are dismissed without prejudice for compliance. All right, and Miss Johnson, there's been an indication you may have a warrant out for you from Lansing, so you should probably turn yourself in, or else she's going to get picked up on a warrant. Okay. Do you understand that, Ms. Johnson? So your files 3738 and 39 are dismissed, but you have an outstanding warrant on another file.
Another file.
Yeah.
All right.
Yep. So you should probably clear that up, or once if that would really ruin your day if you got picked up on a warrant on that outstanding file. If you don't know what that's about, you should check into it.
I will.
All right. Anything else for the record in 26-00137, 38, or 39, Mr. Decker?
Not from the people, Your Honor.
Ms. Rawls.
Nothing from the defense, Your Honor.
All right, Ms. Johnson, all three of these files have been dismissed without prejudice. I would check into the warrant that's currently outstanding. Thank you for your appearance today.
You're welcome. Thank you.
All right.
Is that all, sir?
You're all set, ma'am. Thank you.
Thank you.
Okay, so this is the proof of service. All right, so I can call something. Yeah, I got a proof of service, and the AG's. It looks like the AG's objecting. On Hill, I'm not sure that you've had the opportunity to. We just got the proof of service, so I'll call that eventually in the next 10 minutes or so. What's next, Ms. Flynn?
Your Honor, I think we're ready on Dylan Morton.
Yes, I believe Miss Dalen Morton is on Zoom, and I will be ready on that matter, Your Honor.
Is that me? Where do you have that, Marcy? Oh, I just saw it. Yeah, thank you. All right. All right, so we're on the record in 26-01996. That is People of the State of Michigan versus Daylin Morton. Appearances for the record, Ms. Flynn.
Thank you, Your Honor. Good morning, Gabrielle Flynn, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Daylin Morton, who is appearing via Zoom. Miss Morton, if you could please state your first and last name for the record.
Daylin Morton.
Thank you. And you can hear me, Ms. Morton?
Yes, I can.
All right. This is the time set for pretrial in the matter. Ms. Flynn, how are we proceeding?
Your Honor, at this time, the people do have their necessary witness here, even though this is just a regular pretrial. And an offer has been extended to defendant through defense counsel. That offer is to plead to an added count 3 of domestic violence under 750.8182, sorry, I have that number all mixed up. A 93-day misdemeanor and or a $500 fine. Upon proper plea to that count, we would be dismissing count 1 and count 2, the child abuse and the assault and battery. And the people would further agree to specialty status under 7694A.
That is a correct statement of the offer, Your Honor. I have spoken about it with Ms. Morton. She has indicated she would like to accept that offer at this time. And so we'd request that the court enter that. And then it's likely would be requested to be set for a sentencing and referral to probation. My client has one request regarding the no contact order she would like to make. I can get into that after we handle the plea, Ron.
All right, all right. So my understanding is, Ms. Morton, is you would be pleading to an added count 3 of domestic violence. What are we using as a complaining victim for that, for the added count 3?
I believe that, Your Honor, would be Laura Morton.
Yes, that is Miss Galen Morton's mother, who is here today.
So we'd be dismissing and we'd be adding a count 3 of a DV of punishable by 93 days in jail and or $500. There is a Killebrew agreement that you receive 769 for a status. If I was going to do something different, I was going to sentence you to some jail time in this matter, you'd have the opportunity to withdraw your plea. Is that correct? Is that correct? Mr. Harris, is that your understanding? Ms. Morton, is that your understanding that if I was going to do something different than the Killebrew agreement of 769-4A, you'd have the opportunity to withdraw your plea? Is that correct, ma'am?
Yes.
All right. And my understanding is that you'd be pleading to count 3, and upon successful plea and sentence, counts 1 and 2 would be dismissed. Is that correct?
Correct, Your Honor.
Right.
Correct, Your Honor.
All right. All right. Mr. Harris, may I inquire of your client of her jury trial rights in this matter?
Yes, Your Honor.
All right. Ms. Morton, you understand you have the following jury trial rights in this plea, and I'm going to walk you through those. Okay, ma'am?
Okay.
You have the right to be tried by a jury. You have the right to be presumed innocent, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial. The questioning witnesses are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, I do.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the added count 3 of domestic violence. Is it still your wish today to plead guilty to the added count 3 of domestic violence?
Yes, it is.
All right. Right. I'm going to have you raise your right hand as best you can, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right. I'm gonna bring your attention back to July 21st of 2026 at the offense location of 3821 Walton Drive in the city of Lansing 48910. Were you present on July 21st, 2026 at the Walton Drive address in the city of Lansing on that date?
Yes.
And who is Laura Morton to you?
My mother.
All right. And it's sometime you lived with Miss Morton, is that correct?
Yes, that is true.
All right. So tell me in your own words what you did to offensively touch Miss Morton that was not done in self-defense.
I hit her in her arm.
And she did not wish to be hit at that time?
No, she did not.
And you did not hit Miss Morton in self-defense?
No, I did not.
Anything towards a factual basis, Miss Flynn?
No, Your Honor, thank you.
Mr. Harris?
Nothing from the defense.
Yeah, I find the factual basis to be knowing, voluntarily, and accurately made. I'll refer to probation for the 769-4A treatment. So we'll refer to probation. So, Ms. Morton, you should probably call probation or go to probation, and they'll set up a meeting time for you to go. Is that a fair statement, Mr.
Yes,
Andrews?
Your Honor, I
Okay.
did go over that. I advised that since she's appearing via Zoom today, it's likely the court would give her 48 hours or
Yeah.
whatever time she needs to
So
get to probation.
correct. You'll probably so you should call probation or go to probation by Wednesday at 5. Set up a meeting in order to go to probation. What they'll do is they'll put a report together for me, and we'll see what options are available to us at sentencing. All right, ma'am?
Okay.
Probation's on the 5th floor of the City Hall of Lansing, and it's all the way to the right.
Okay.
All right, and we'll set your sentencing date for August 17th at.
That enough time to get a.
Yeah, that's probably, it's got to be 6 weeks. Yeah.
Thank you.
Yeah, I don't think they'll have a report done in
September 14th.
September 14th at 1:30. All right, we've set your sentencing on September 14th at 1:30. We'll see what options are available to us on that date. You should go to probation or at least contact probation by Wednesday at 5. All right, ma'am?
Okay.
Anything else for the record in docket 2601996, Ms. Flynn?
Not for people.
And I know, Mr. Terry, you had at least a motion to make.
Yes, Your Honor. Ms. Morton was asking if I could make a request to the court to consider the no contact order. I believe because of the child abuse, it also includes the children. She has been having a very difficult time without being separated from her children like this. I understand if the court still has concerns. Given that the child abuse has been dismissed, I would ask if the court would consider modifying the no contact order to allow some kind of peaceful or perhaps supervised contact with the children. I did speak with Ms. Morton regarding that and advised that it's possible the court may want to wait until sentencing to address that, but she did still wish that I at least put the request on the record today.
All right, thank you. Any response from the people, Ms. Flynn?
Yes, Your Honor. At this time, we would ask that no contact order remain in place at least until the beginning of probation, if that's what's ordered, in the beginning of those cognitive classes or batterers intervention classes, just for the safety of all parties involved. That count 1 was not dismissed based on lack of ability to move forward, but out of plea negotiations. And we would ask that it remain in place until it can be determined that it is safe for all parties to be involved again.
All right, at this time, I'm going to deny the modification of bond until I hear from the probation department. We'll readdress its sentencing. And then, Mr. Harris, you can bring the motion up, or at least allocute at sentencing. And they'll contact Miss Morton also, so she'll get a say on the subject. So Ms. Morton, you'll be contacted by the probation office concerning some activity here. Make sure you let them know how you feel on the case. All right. All right. But I won't do anything until sentencing. So till September 14th at 1:30. Anything else for the record in 2601996, Ms. Flynn?
Not for the people.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Ms. Morton, we'll see you on September 14th at 1:30, and you should be referred to probation. You should contact them by Wednesday at 5. Okay, ma'am?
Okay. Thank you.
All right. Thank you. You're all set. Mr. Rawls, did you want to go on Mr. Trevino? Or we?
Yes.
Okay. All right, Mr. Trevino, we'll call your case. We're on the record in docket 20 402-993. That's People of the State of Michigan versus Ronnie Trevino. Appearances for the record, Ms. Flynn.
Thank you, Your Honor, and good morning, Gabrielle Flynn, Assistant Prosecutor for the People.
Ms. Rawls.
Assistant Public Defender Linda Rawls, appearing on behalf of Ronnie Trevino, who's present via Zoom.
And sir, you are Ronnie Trevino, is that correct?
Yes.
And you can hear me all right, Mr. Trevino? Is that a yes, sir? Okay. All right. This is the time set for a pretrial in the matter. Ms. Flynn, how are we proceeding?
Your Honor, at this time, the people have extended an offer to the defense through defense counsel. That offer is for Mr. Trevino to plead to count 2, operating while intoxicated. And upon proper plea to that count, the people agreed to dismiss count 1, operating with a high BAC.
And is that a fair statement, Ms. Rawls?
Yes, Your Honor.
All right. And does Mr. Trevino plan on accepting or pleading to the offer of an added count 2 of operating while intoxicated? That's punishable by 93 days and/or?
I believe a $500 fine.
Ms. Rawls, does Mr. Trevino intend to plead to the added count 2?
Yes, he does, Your Honor.
Okay. All right. So, Mr. Trevino, my understanding is that you're going to plead guilty to the added count 2 of operating while intoxicated. It's punishable by 93 days and/or $500. Ms. Rawls may inquire of Mr. Trevino of his advice of rights.
Yes, you may, Your Honor.
All right. Mr. Trevino, you have the following jury trial rights in this matter, and I'm going to walk you through those rights. All right, sir?
Yes, sir.
You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Linda Rawls, and she will be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yeah.
All right. You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. It's my understanding, if you're pleased accept, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the operating while intoxicated misdemeanor instead. Is it still your wish today to plead guilty to the operating while intoxicated misdemeanor?
Yes, sir.
All right. I'm going to have you raise your right hand as best you can. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, sir.
All right. I'm going to bring your attention back to July 4th, 2024 on Martin Luther King Boulevard. So this is an ad. So this is in the there's an ad count 2.
Yes.
Yeah. So he'll be pleading to count 2 and count 1 is dismissed.
Yes, Your Honor.
Okay.
Thank you.
Thank you. All right. So were you operating a motor vehicle open to the general public on Martin Luther King Boulevard in the city of Lansing?
Yes, sir.
And what were you operating, sir?
Sure. I should do that.
All right. And at some time did you learn that while you were operating with a blood alcohol level of over 0.08 grams?
Yes, sir.
All right. And what was the blood alcohol level, if you recall?
You know,
You have no reason to dispute it was 0.239.
it was over the legal.
All right. All right. Anything towards the factual basis for count 2, Ms. Flynn?
No, Your Honor. Thank you.
Ms. Rawls?
No, Your Honor.
All right. I find the factual basis for count 2 to be knowing voluntarily and accurately made. will refer to probation for an assessment, because that's typically what's done. And I think by law, they have to have an assessment under the statute sentence. So we'll set the sentence for, it's got to be six weeks out for assessments. September 14th at what time? 1:30. So we've set it for September 14th at 1:30. Probation will be contacted to go down and see you if you're still incarcerated. And then they'll put a report together to be seen by myself, and we'll see what options are available on September 14th at 1:30. Anything else for the record in 2402993, Ms. Flynn?
Not for the people, thank you.
Ms. Rawls.
Nothing from the defense.
All right, Mr. Trevino, you should be. Did they turn off the light or?
Yeah.
Mr. Trevino, are you still there? Okay.
Yeah.
All right. All right. So I'll see you on September 14th at 1:30. Probation should be down to see you, sir. All right.
Yes, sir.
All right. That's all for the record in 2402993. You should be all set, Mr. Trevino. You can tell him you're all set.
Thank you.
So, Mr. Reed, I'm going to place you in room 2, and then I'll place your public defender in room 2. All right. What's that? Mr. Williams? Okay. Mr. Harris, who has Mr. Williams?
That would be Ms. Rawls.
Okay.
If Mr. Williams is failure to appear, I
think he's a failure to appear. They had him Friday, and then he was incarcerated Friday, and he's not incarcerated anymore. So
yeah, it's a failure to appear. I can address that.
We'll have Susie call the hallway for Drees Williams. Yeah, you just did?
Empty hallway.
All right. All right, let's call that case. So we're on the record in 2600525. That is People of the State of Michigan versus Drees Williams. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of assigned counsel, Ms. Rawls, who's currently speaking with another client for Mr. Drees Williams, who unfortunately does not seem to be here in person or via Zoom, Your Honor. And at this point in time, I don't exactly have any information to convey regarding why Mr. Williams has failed to appear. I would request of the court consider a 48-hour hold rather than an immediate bench warrant.
All right, this is the time set for a pretrial. My understanding is Mr. Williams was being held on other charges up till Friday, and then he was let go over the weekend, and so he hasn't appeared today. I do not have this as his first fail to appear. I have a prior fail to appear on April 6th, a prior fail to appear on May 4th. So 2 prior fail to appears. He was arraigned on both those bench warrants at that date. Bond was set at, looks like $100, 10%. So it was like, it was a low bond. We reset this from an August we reset this for August 3rd on July 20th. Mr. Decker, how would you like to proceed?
We would just ask the court for an immediate bench warrant based on the assaultive nature of the crime and the prior failures to appear.
Has your office had any contact with Mr.
Don't believe
Mr.
since
Williams?
he's been released.
Okay.
Your Honor.
All right. I do not see a Dries Williams in the Zoom courtroom. There's nobody in the physical courtroom. We call the hallway. It would appear the defendants failed to appear today. And I will, because this is a third fail to appear, I'll issue an immediate bench warrant. Anything else? So for the fail to appear, I'd issue an immediate bench warrant on this file. This was scheduled for 9:30 and it is now 11:15. Anything else for the record in 26-00525, Mr. Decker?
Nothing from the people, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, we're all set on Mr. Williams.
What did Ms. Roslin speak?
You need to speak with Mr. Reed, and I already put Mr. Reed in room 2. So, Ms. Rawls, I'll put you in room 2.
Yeah, that's right.
And then we can go on Miss Kill, but I don't think we have that. We just got proof of service, and then the AG does object.
Correct, Your Honor, and I have not had the ability to
Yeah,
look at this
so-
case yet. Because we
so-
actually just received that notice on Friday.
Yeah, I mean, so no, we just received notice on the 10 o'clock today from the prosecutor's office. So I'm going to give them some time to look in, Ms. Hill, but we'll call this case. So we're in the record on docket 1504385. That is a motion to set aside the conviction and appearances for the prosecution, Ms. Flynn.
Thank you, Your Honor. Gabrielle Flynn, Assistant Prosecutor for the People.
And ma'am, you are Briteria Hill?
Yes.
All right, thank you. This time is set for a order on application set aside a conviction. There is an Attorney General objection to setting aside the conviction, and the people have not had time to check in to see if they object also. Is that a fair statement, Ms. Flynn?
It is, Your Honor.
All right. We just got proof of service today for the prosecutor, and the prosecutor probably just got proof of service, I would think, July 22nd. They said they got it just on Friday.
Got processed into our file.
Yeah, it was served on Wednesday. I mean, that's the name. So I'm going to adjourn this hearing. So we'll adjourn the motion to set aside, and then we'll reschedule it. There is an objection, and I'll read that into the record from the Attorney General's office. Do you have that, Ms. Hill?
Okay, you can go ahead with it. I'm ready.
Okay, I can read into the record the nature of the Attorney General's motion. It says Attorney General's answer to defendant's application to set aside a conviction. Now comes Dana Nessel, Attorney General for the state of Michigan, who responds to defendant's application to set aside conviction. Defendant asks this court to set aside her 2015 conviction for a moving violation causing serious impairment of bodily function. Under MCL 780-621, an applicant may have up to 3 Michigan felony convictions and potentially an unlimited number of misdemeanor convictions for the record to be set aside, albeit with some restrictions and caveats. Certain offenses are ineligible under the statute, and an applicant may only apply after either 3, 5, or 7 years have elapsed since the completion of the respective sentence for a conviction. Hill's criminal record reveals that she was convicted of the following offenses: a misdemeanor out of 2015 for motion to violate causing serious impairment of bodily function. Hill's conviction of a moving violation causing serious impairment of bodily function is ineligible for set aside because it is a traffic offense that involves causing serious injury or death. Accordingly, based on the information above, the people respectfully defer to this court on ruling on Hill's application set aside her conviction. All right, so do you understand the nature of the Attorney General's request that we do not set aside your conviction, Ms. Hill?
No, Your Honor, I don't understand. What is?
All right,
exactly?
we'll send you the application set aside. We'll email it to you. You probably should have an email address that we can send it to. Do you have an email address we can send you the application? I
Yes.
think they're under duty to serve it to you. And it says that they were served, that you were served at the Lakeside apartment address in Texas. Is that still a good address for you, ma'am?
Yes.
So at 800 Lakeside apartment 113 is still a good address. So you've been served this already. Is that correct?
Yes.
Okay. All right, then we will not send it to you because you've already been served this, and we will adjourn the hearing, the motion to set aside,
Well,
and
so what I was sent was just the paperwork that I needed to send back in to the Attorney General and the court, but they didn't tell me why they objected me setting
they have
aside.
they have a proof of service that they served it to you at the Lakeside, Louisville, Texas address, and they have it served on July 7th of this month, of last month. It's at July 7th of 2026. We can resend it if you'd like, but this is a proof of service that you've already been mailed this response to your motion to set aside.
No, I thought that you were saying that they would send me like in writing a reason as to why they're objecting.
I just read it into the record. I read their entire motion to set aside the conviction into the record.
And you also said that you would send it to me, correct?
If you want it sent again, we'll send it to the same Texas address that
See,
that you
that's
received
what I'm
service.
that's what I haven't. No, they never told me that they objected. I never received that. The only thing I received was the paperwork that I sent back
All right,
into the court.
I'll send it to you as a courtesy, and we're going to give the prosecutor time to check on whether this is an eligible conviction. We will also send it to the prosecutor, the AG, the AG's motion objecting to the set aside, and we'll set it for probably a month out, I would think.
Okay, and when you read it, I was under the impression that they said that they're objecting because it was a serious injury, like bodily, he could have died or
That
something along those.
what they've indicated does not fall under the what you can set aside. It's a traffic offense that involved causing injury or death, and so they've set an objection.
So is that
So we'll
ever going
send
to
that.
be able to be set aside?
I think it's 3, 5, or 7 years is but you can read the motion, but
Well, this happened in 2016, and I've already been denied once, so that time
ma'am,
has passed.
I'm not going to argue with you. I'm just going to provide you with the motion and the objection, and I'm sure you're able to contact the Attorney General's office.
Okay.
All right. So we'll set it for an adjourned hearing for August 31st at 10 o'clock. All right, we've set it for August 31st at 10 o'clock. We will send as a courtesy a copy of the objection, and that would give the prosecutor's office some time to look to see if they also object.
Okay.
And that objection will be sent to the Texas address as indicated.
Okay, thank you, Kamala. And I just wanted to let it be known, I wasn't looking to argue. I just was trying to get a clear understanding. I wasn't trying to.
All right, I understand. We've set it for August 31st at 10 o'clock, and we will send you a copy of their objection. And it runs about, let's see, 1, 2, 3, 4 pages with the proof of service. Anything else for the record in 1504385, Ms. Flynn?
Not for the people.
Ms. Hill, do you have any questions of me?
So do I do the same? I just come back here on the Zoom call, August 31st?
Yeah, exactly the same. Come on August 31st. That would give the time for the prosecutor to pose any objections because of late proof of service. And we will send you a courtesy copy of exactly what we have to the Texas address.
Okay. And one last question that I have, is there anything that I can do that would appeal to the fact that of them objecting it?
You'd have to contact the Attorney General's office.
Okay.
Yeah, and they're not objecting to it. They're objecting to it because it doesn't fit under their definition of traffic offense that causes injury. But you could discuss that with them.
Okay, thank you.
All right, we're all set on 1504385. Thank you for your appearance today.
Thank you. Bye-bye.
All right. Did you want us to bring back Mr. Reed? Right. Probably because they're all done, except for
It sounds
Mr.
like Reed
Reed.
must have gotten bounced off Polycom. That might have been why.
I wasn't able to meet with him.
Maybe that's why the jail's calling. All right. So I still have you, and he's on Polycom, so I can put you back in the room with him. All right, Mr. Reed, I'm going to place you in with your attorney. The indication that we had some technological issues, but I'm going to place you in room 1, and then I'll place Miss Rawls in room 1 when she gets here. Okay. Little Zoom management. I don't know why we have Angel.
Like,
All right, Miss. I'm gonna bring back.
Council.
Oh. Ms. Rawls, did you need some time to talk to the prosecutor? All right, so we're on the record in 26-01609. That's People of the State of Michigan versus Jack Reed III. Appearances for the record, Mrs. L.
thank you, Your Honor. Good morning, Gabrielle
Or
Flynn,
Miss Flynn.
Assistant Prosecutor for the People.
Ms. Rawls.
Good morning, good morning, Your Honor. Assistant Public Defender Linda Rawls appearing on behalf of Jack Reed, who's present via Zoom.
And sir, you are Jack Reed III, is that correct? Is that a yes?
Yes, I am.
Okay. And you can hear me all right, Mr. Reed?
Yes, I can hear you.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Flynn, how are we proceeding?
Your Honor, it's my understanding that at this time, we're going to ask for a second pretrial in this matter so that we can continue negotiations.
And is that a fair statement, Ms. Rawls?
Yes, it is, Your Honor.
Okay. So set for second pretrial for August 31st.
Oh, yeah.
At 9 o'clock. All right, at both parties' request, we'll have a second pretrial set for August 31st at 9 o'clock. Anything else for the record in 26-01609, Ms. Flynn?
Not for the people, thank you.
Ms. Rawls?
Nothing from the defense, Your Honor.
All right, Mr. Reed, we'll see you on August 31st at 9 o'clock. Thank you for your appearance today.
Okay. I see.
Question, Your Honor. If we could start with the sentencing.
That is Mr. Gorney.
Thank you. Yes, that one.
Then Mr. Harris, you'll be covering for Miss Wunsch.
That is correct, Your Honor. Apologies that I'm lacking a tie and my usual core wear attire. I was asked kind of last minute after I came here to watch what I thought was a colleague in jury trial.
We're fine. All right, so we are on the record. Let's see. We're on the record in docket 2601-046. That is people of the state of Michigan versus Matthew Paul Gorney. Appearances for the record, Mrs. L. Or Miss Flynn.
Thank you, Your Honor. Good afternoon. Gabrielle Flynn, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here standing in for assigned counsel, Assistant Public Defender Melanie Wunsch.
No, my name is Dusty Wildman, right?
Unfortunately, I had to be in another courtroom at 2 p.m. and asked me if I could cover this.
All right.
Mr. Gorney is standing to my right. Mr. Gorney, if you could please state your first and last name for the record.
Matthew Gorney.
All right, thank you. This is the time set for sentencing in the matter. Miss Flynn, I don't see any further restitution on the matter. Do you have any further restitution on this matter?
I was just double checking, Your Honor. It does not look like we have any.
All right.
I do not see any, Your Honor.
I didn't see any either. I didn't see. The victim submitted an impact statement, and that statement has been included with the file. Let me see. But I don't see any. I don't see any. And I don't see any restitution.
I do not see any either, Your Honor.
All right. Have you had the opportunity to go through the pre-sentence with the court? Have you had the opportunity to go through the pre-sentence report with Mr. Gorney, Mr. Harris?
Yes, Your Honor. He went over it with Ms. Wunsch.
All right. Do you know of any deletions, additions, or corrections?
I do not, Your Honor.
All right, allocution, Mr. Harris.
Yes, Your Honor. I will note that Mr. Gorney is here today for his sentencing. He's here with support. And as indicated in the PSI, it looks like he did, well, it stated he did take full responsibility for his actions and expressed a great deal of remorse. Sounds like he was dealing with some issues with drug use that he has since been trying to resolve. He does have a sponsor who I believe is here with him today for support. He is in a sober living community. He's completing treatment. I believe he does also have a separate district court matter for the 4th district court where he's expecting to get probation on that as well. It sounds like Mr. Gorney is recovering, Your Honor. This was a moment where he saw the way his life was going and did not appreciate the direction he saw his life going in and tried to make a change. It sounds like he has been reasonably successful so far in making that change.
Oh, no, my name is George Wildman, not Gorney, but okay.
And he is willing to submit to all terms of probation and believes that it's likely he will be able to complete probation. I would simply ask, Your Honor, if the court would follow the recommendation here and sentence him to the 8 months of probation regarding fines and costs. I would ask that the court consider minimizing what fines and costs it can, so that he can more appropriately put his limited resources towards cost of probation, cost of programming, cost of the random PBTs and the like. And my apologies, Your Honor. I did just notice a note here from Ms. Wanji that he is employed full-time, so that would need to be a change to the PSI.
All right. Where's the
What am I
employee at?
here for?
Daytime
Ma'am,
construction.
what am I here
Grant.
for? My name's Darcy Wildman, not where you say.
Mr. Wildman, Mr. Wildman, you're gonna have to be quiet. We're gonna rein you in just a second, all right?
I'll keep it up.
All right. Mr. Gorner, is there anything you'd like to say to the court before the court passes sentence?
Your Honor, I my attorney said, I do take full responsibility for everything that happened. I'm on a better path in my life, and I've been taking the steps and avenues to correct some of the things that I was doing wrong. I just ask that the court can just help me any way possible to continue on this path.
You have a recovery coach with you, is that correct?
Yes, Your Honor.
What's his name?
Roger, May.
And who's Roger? Okay, all right. And what company are you with?
Rise.
Price? Okay. All right, Ms. Flynn, is there anything you'd like to say before the court passes sentence from the people?
No, Your Honor, we would ask that you follow the probation recommendation at this time. Thank you.
Well, Mr. Gorney, you present a problem to the court, okay? Because your criminal history is not good, okay? And you failed at probation before, okay? I understand you're in a different place now, and that's to your credit. You've got some warrants to clean up on, you know that. But Mr. Gorney, I believe in you, and so I'm going to give you an opportunity. I'm going to do what the probation department has requested. The probation agent I know, and I think highly of. He's a pretty flexible guy, and he has told me before, like, I'm not going to work with this person, and I've trusted him. He believes he can work with you, and that's all I need to hear. Okay. But your criminal history kind of speaks for itself. So whatever you're doing, keep doing it. Okay. Whatever you're doing, whatever road, whatever path you've taken, it seems to be effective. Okay. So it is the order of this court that you spend 22 days in jail. Credit is given for 22 days previously served. And then we'll go from there. If you violate probation, it's 5 days. That's essentially it. 5 days per and first offense, 10 days for the second, 15 days for the third. That's how it works. You know that you've been through this. This isn't your first time in the system. You're not a kid, and I'm not going to treat you like a kid. It's 22 days previously served as a credit. Fines and costs. You're gonna hit $100 fines, $100 costs. Crime victims' rights of $75. State minimum cost fee of $50. Place you on probation for 8 months at $30 a month. So that's $240. So I'll give you a grand total. You can pay this amount at the end of probation. So it's $240 plus $200 plus 125. That's not right. It's 240. It's 200. That's 565. Probation is set for 8 months, or for eight months at $30 per month. Zoom reporting is allowable, so make sure you know how to contact Mr. Neves. That's your probation agent. Mr. Neves is the person who would violate you, okay? There's no assaultive or threatening behavior. Not to purchase or possess a firearm or a dangerous weapon as a part of this. No use of possession of alcohol, marijuana, or controlled substance without a valid prescription. No use or possession of kratom, and I'll write that in the comments. Provide proof of all medications, of prescribed medications.
Yeah. Yeah. No.
Submit to random PBTs and your analysis as directed and pay the fees. That's kind of the big thing here. And so if you, I'd say 80% come to me because they dropped dirty. That's why we have probation violations. If that's not the case with you because of your sobriety, then it's your time to shine. Okay, sir? All right. So submit to random PBTs and your analysis. No bars or nightclubs is probably a good idea. Obtain and maintain employment as you've done. I've never violated anybody for not maintaining employment. So usually we're busy enough just trying to, with the violations for the use of alcohol or drugs. Do you understand the nature of your probation, sir?
Yes, sir.
All right. Mr. Gorney, this is, to say it's a crossroads would be an understatement, okay? But I'm not worried about Matthew Paul Gorney now, okay? Because you're on probation to me for 8 more months. I'm really worried about Matthew Paul Gorney 4 or 5 years from now, when you've got to make good foundational decisions about where you are and what your decision-making process is. I know it's not easy. I know that every day is going to be a struggle, but use district court as a resource. Use us to help you, okay? All right. Anything on the judgment of sentence of Ms. Flynn?
No, Your Honor, thank you.
Mr. Harris. All right, I'm going to sign the judgment of sentence. Mr. Gorney, good luck to you, okay? Thank you. Yeah, let's do a clean one on that. I wrote all over that one.
Your Honor, do you need my appearance for anything else?
I do not, I don't think so, Ms. Flynn. I think you are all set.
Yeah, just want to make sure.
All right, let's go on to Mr. Wildman while we have him.
I apologize for interrupting. I just didn't understand.
You're all right. You're all right, Mr. Wildman. We'll see you, Ms. Flynn.
Bye, have a good afternoon.
All right. All right, so we're on the record. This is a show cause for 25-01424. That is People of the State of Michigan versus Darcy Wildman. And sir, you are Darcy Wildman, is that correct?
Yes, sir. Yes, Your Honor.
All right, thank you. All right, this is the time set. I have a balance due. Because that's what the show cause was set for. I have a balance due. What's the computer say? Because I've got somewhere along $75.
Oh,
it's on a hinder. It's based on a hinder and oppose. 75. All right. So, Mr. Wildman, were you incarcerated on this charge? Or did you have another charge that you're incarcerated on?
I keep telling, I'm supposed to pay that 75, which I wasn't able to. If I was able to get released today, I'll be able to pay for it. I just got paid today. I get SSDI.
Well, let's do this, Mr. Wildman. I think you were incarcerated set for show cause on August 3rd, July. That was for July 15th. So you must be in on something else.
Uh,
Were you in as of July 15th?
I think so.
All right.
Pardon me,
All
I
right.
have severe head injury, so it's
I
hard for me to
understand.
remember.
I'm going to administratively close this file, ACMC, for balance of $75. So you're not so you won't be responsible for the $75 debt. And in some ways, you've already paid it by being incarcerated. So you should be all set, Mr. Wildman. I'm ACMCing this file, which I'm administratively closing this file. Okay, sir?
So I should be released today?
Okay, so he's here he's on a different file. Okay. So Mr. Wildman, I think you're on a different file. I don't think you're on this file, but I'm closing this file, okay? So your balance of $75 has been closed, and then you should be able to see what else you're on, which is probably a separate file to this.
How am I going to get released?
I have nothing to do with the other file. I was just on this file, and this file's been closed. Okay. So I don't know about the other. I don't know about the underlying file that you're being held on, but this file's been closed. All right, sir.
I'm going with you then.
All right. You should be all set, Mr. Wildman. Thank you for your appearance today.
Yeah.
All right. Well, then he's in on that one. Yeah. And he was never going to. All right, so we're on the record in docket 2502880. That's People of the State of Michigan versus Malone Tucker. And sir, you are Malone Tucker, is that correct?
Yes, sir.
This time set for arraignment. I'm going to indicate to you some of the charges that have been brought against you by your probation officer. Brendan Hanna wrote as of July 22nd, 2026, I allege that the defendant has committed the following non-technical probation violation: failed to adhere to contact order on or around July 19, 2026, and failed to display assaultive threatening behavior on or about July 19, 2026. Do you understand the nature of the non-technical probation violations that have been brought against you by your probation agent, Mr. Hanna?
Yes, I do.
All right. You have some rights in this file, and I'm going to walk you through those rights. You have the right to counsel. You have the right to hearing. We're going to set it for hearing within 14 days. The right to counsel is you were previously represented by the public defender's office. I would think it's a good idea that you'd go back to the public defender's office to be represented on this file. Would that be a fair statement, sir?
Yes, sir.
All right. Let me give you how it works is a little different. We don't have a public defender here for this arraignment purposes. You're being arraigned on a probation violation.
Yes,
so
sir.
I'm going to give you the number for the Ingham County PD. Yes. And you can call them in order to get representation, and I'll give you the hearing date. So the hearing date is August 17th.
Okay.
At 1:30. you should have that August 17th date, August 17th at 1:30. And when you call the public defender's office to seek representation for this probation violation hearing, you should give them that date. So that would tell them it's usually Mr. Harris or Miss Rawls are assigned to the court. Okay.
Okay.
It's for probation violation hearing. Yeah. So it's got to be within 14 days. And I think that is, let's see, August. No, it's got to be within 14 days. So August 17th to be outside that. But it's 4th. Let's see, 4, 6, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. That's 14th. That's the 14th day. So that day's good. August 17th at 1:30 is good. And the number of the public defender's office is 517 679 2979.
Okay. I have a question.
Right.
So I'm on the
Sure.
road. Is there any way that I can maybe do these next couple dates on Zoom?
No, you have to have your hearing pursuant to statute by August 17th. You can ask for an adjournment, but you should probably talk to somebody from the public defender's office who could file that motion for you.
Okay. How soon do I have to put that motion in?
I would do it. I would set it as a priority as soon as this afternoon.
Okay.
The motion, it doesn't matter, but I would call them immediately. I'd call that number that I just gave you immediately.
Okay.
All right. So we're set for August 17th at 1:30. You should be all set. Thank you for your appearance today, Mr. Tucker.
Thank you. Bye.
This is the sentence, right? It always goes in the one I found. Those are two for the sentence.
Yeah, violation condition. Okay.
And then
Oh. That's a good idea.
all right, Mr. Bloor, you can come up here. All right, so we're on the record in docket 2501618. That is people of the state of Michigan versus Keith Bloor. Appearances for the record, sir, you are Keith Allen Bloor, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probation violation, and I'm going to indicate to you some of the allegations that were submitted by your probation agent concerning this process. It appears that your probation agent, who is Nathaniel Neves, violated you for a technical probation and so here are the violations. They're listed as violation number 14, but that doesn't mean there's 14 violations. Yeah, it's just that doesn't mean there's 14. It's just how we label them. Okay. So per AberHealth, defendant tested positive for alcohol on June 8th, 2026. And per AberHealth, the defendant tested positive for alcohol on June 25th, 2026. So 2 positive tests for alcohol are the reason for the technical probation violation. You were represented. You had Mr. Freeman on the underlying case. So you were represented by the public defender. Is that correct?
Yes.
All right. All right. So we will set for hearing on probably the same date, right? Yeah. So August 17th. That's August 17th at 1:30. Okay. So we'll set for August 17th at 1, turning your probation violation hearing. You have the right to counsel, you have a right to hearing. We're giving that hearing. I'm going to give you, and I don't know if you, but I will give you a note with the public defender's office on it. You're going to have to call and make sure you have representation on that date. I think it's a good idea, okay? Because it started out as a felony, but you pled to a misdemeanor in this. That's why you're on probation. And it's probably a good idea to talk to a lawyer before so you understand the ramifications of what you're doing. So the public defender's office, Susie, do you have their number or should I write it down?
I don't think I have the number.
Let me write it down and then I'll give it to you. All right. So this number that we're giving you, write down August 7th, or we'll write down August 17th at 1:30. When you call this number, tell them that hearing date. And then you'll be represented. It's usually Miss Rawls or Mr. Harris are assigned to this courtroom. But you should talk to one of them just to make sure they understand the nature of the probation violation. It's for testing positive for alcohol. Okay. We'll set for August 17th at 1:30. So you have the date and time and the number.
Yes, sir.
All right. All right. You should be all set. I will see you on August 17th at 1:30. And you should talk to Mr. Harris or Miss Rawls prior to that. Okay. All right. You're all set. Thank you. Laura. I think I did. I didn't mean to. And that's why you kind of have to, because we could label those 23, 24, 25 violations. You're like, it doesn't mean it's 23. I think that should be the criminal docket. Yep, and then we've got civil stuff starting at 2:30. I don't know who's going to show up for
Anything.
Yeah. We know what's not going, and that's the bench trial.
Yes, thank goodness.
But other than that, and
I
I know
gotta upload this stuff.
I know Mr. Akane, I asked for that hearing since he submitted paperwork and I set it for hearing. I'll look at the other ones. But I don't think, I think all the 2:30, all the 3 o'clocks are gone. The discovery. So Susie, I don't know if we'll need you for 2:30.
That's what
Yeah.
Marcy had already said.
So
Which is good.
yeah, you get to go back and do normal work.
Just a little bit.
Yeah. Do the work that you signed up for as opposed to the work that you didn't sign up for. All right.
It always takes me forever to sign in that. I cannot wait for the new computer.
I can't either, but it's going to come with its own set of problems.
Well, tomorrow though, tomorrow I'm supposed to get a new computer, so.
Did you go see the new building? Did you do either of the tours?
I did.
We did like a month and a half.
Yeah, I did about a
ago.
month and a half ago, and they didn't have they had the structure all set, and they had like the very makeshift of a courtroom, but we didn't see it up far along as you guys saw.
Okay.
As alignment last week, and he said it was further along.
Yeah, it was.
Yeah.
Looking good.
Yeah. So
yeah.
Oh, did you go last?
I did.
yeah,
Okay.
it's kind of because you just hear about it, and then to see it is another thing.
Mhm.
Just seeing the structure already built was
Yeah.
it kind of makes, for me, it got me very nostalgic about this building. But
I don't think I'm gonna miss it.
But I recognize all the limitations this building has. I mean, this is the finest technology since 1950. All right, Mr. Sobe, you're here on the Pennsylvania Flats versus Ariana White case.
I am, Your Honor. Good afternoon.
Good afternoon. And I just signed a consent judgment of that. Were you just, is that?
Yeah, I sent an email asking if it was going to be removed from the docket, but I never got a response. So I said I'll just show up just in case.
It's not a bad idea. It's not a bad idea. Just make sure. But I did sign that consent judgment, so you should be all set.
Perfect. Thank you, Your Honor. Have a great day.
You too.
Thank you.
And then, Mr. Brock, you're here on 20-03-116. That's your objection to set aside. Is that correct?
Yes.
All right. And that, Mr. Kuipers, you're here on that case?
Yes.
All right. Let me pull that up. I'll pull that case up. Oh, I think I have a regular file on that. Yeah. And Mr. Kuipers, did you want the opportunity to speak with Mr. Brock in a breakout room before we call that case?
I don't think so, Your Honor. I don't think it's necessary.
All right. All right, so we're on the record in docket 20-03116. That's Orbit Leasing Company versus Christopher Brock. Appearances for the record, Mr. Kuipers.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff. Or good afternoon.
And sir, you are, that's all right. And sir, you are Christopher Brock, is that correct?
Yes, sir. Yes, Your Honor.
All right, thank you. This is the time set for a motion. I have here a petition by Christopher Brock indicating, and that's what we're hearing today, and I'll read it into the record. Mr. Brock indicating, I cannot afford to be garnished due to financial hardship, and they will be receiving my state taxes that were offset, which will pay off what is owed. I've also attached copies stating they will receive the money owed. They received form 74, I think it's 3, on July 16th, 2026, and it was dated July 20th, 2026. Mr. Brock, is there anything you want to say in supplement to the motion?
Yes, I also received something from the state of Michigan that's a notice of income tax refund used for debts. And it says that because I think I owe $3,200 something or something like that, that's still owed. And they are paying them, and it says that the payday is tomorrow. I have the paper in front of me, $3,776.
There is a refund due to you. I have the Michigan Department of Treasury is holding your income tax refund for the tax year listed above. It's listed as of 2025. So that taxable income is being, and it may delay your refund for up to 4 months. Enclosed is an income allocation from the non-employee. Is that the state of Michigan?
Yes, it is. Yep.
Speaking of. Okay.
Yes, and I did all of that first so they can just take the whole refund. And then I got something in the mail that it's dated for August 4th about the account stating that they're going to be sending them the money and that it'll be paid to them tomorrow, August 4th.
All right, and I have the debt, the garnishment and the debt details were $6,500. Does that sound right? That's on the state of Michigan.
No, that's not that's how much the total was. That's not what is left owed on the account.
Okay. Response, Mr. Kuiper.
Your Honor, that's how much was owed at the time the garnishment was filed back in 2025. Right now, I mean, I see that the disclosure from the state of Michigan showing they're withholding the refund amounts $3,776. I don't know how much is being withheld. The current balance is $3,225.30. And right now the defendant's $1,000 in arrears on the payment plan. So while I understand where the defendant's coming from, I don't have authority to withdraw the motion, and I guess I'll leave it to the court's discretion what the court wants to do here. I mean, definitely the defendant's in default on the payment plan, but I do understand it looks like there's a payment coming from a tax garnishment, although I don't know when that is coming. We don't have it yet, so.
Right. And so we're kind of waiting for the state of Michigan refund amount to be garnished. Is that correct, Mr. Kuipers?
Yeah, I guess that's one way to put it, Your Honor.
Yeah, I mean other than the defendant being $1,000 from the payment plan, it was the count is currently 900 past due. That was as of. So, Mr. Brock, the amount of the full judgment, and then there was an agreement to pay $100 every week. Is that right?
Yeah, and then there was times their system had went down, and my wife was in talks with Orbit Leasing, and they're telling us that they're still receiving the payment, and they weren't receiving the payment, and then all of a sudden I'm $900 behind.
Yeah, but that's not Orbit's fault, is it?
That their system was down, it was automatically coming out of my bank account.
Mr. Kuipers, was the system down and then Mr. Brock's money was not coming out of his account?
I'm not sure, Your Honor. It looks like money was coming out, but then it looks like it got credited back. I don't know if there's insufficient funds or what, but this all happened between June 19th and June 23rd. And then it also happened prior to that. A couple payments got returned in April 30th, and then one in February of 26. So, and then nothing's come out since mid-June.
Well, this is what the court's willing to do. I'm willing to set this objection in abeyance for 30 days to see if you get the tax money back, but we don't know how much that tax, and then we can go on what the actual debt is. I have a refund amount of $3,776. I'm assuming that's the amount that needs to.
Yeah, they're taking that whole amount because I can bring a copy of it up there. Yeah, I know. It says on here, it says disclosure date or pay date if state employee 8/4/2026.
Yeah, then they don't. So, and today's August 3rd, and
yes,
it was supposed to be released August 4th. So I can adjourn this so you can get the tax money back, and then you'll have a date of the remainder, and then we'll see if Mr. Brock indicates. But I'd like to get that tax money. That should be a part of the if adjourning it a couple weeks would get you the tax money. I just don't know. I know when they say it's going to be released, I just don't know if it's going to be released.
I understand.
Yeah. So, Mr. Kuipers, I would think that we'd adjourn it, I don't know, 2 to 4 weeks to see if you get the tax return money, because there's a hold on the tax return money, and then you'll have your total ledger. But that I guess I'd like to see that first, because that might change our approach.
Understood, Your Honor. I guess will the court then send out a new notice date?
Yeah, I can think I will keep it. We won't. So we'll adjourn the motion for at least 30 days to see what the tax responsibilities are concerning the letter, which was dated April 10th. So, and it says August 4th. We'll adjourn 30 days, and then we'll see what the ledger is, and we'll go from there. So adjourn 30 days to
August 31st.
So we'll set it for August 31st at 2:30. So all I've done is adjourn the motion, and then if you get this money from the state of Michigan, you can apply it to the ledger, and then we'll have a full balance. But I think that's what we're waiting for, Mr. Brock, is that money to come in, so that we know the actual distance as opposed to the difference in theory.
Okay.
Would that be a fair statement, Mr. Kuipers?
Yeah, yes, Your Honor, and that's August 31st at 2:30.
Yeah, August 31st at 2:30 is the time for the adjourned hearing date, August 31st at 2:30, and then we'll see how much of the refund from the state of Michigan Orbit Leasing gets, and then we'll go for the remainder of the debt at that time. But I don't think, yeah, without knowing how much money, it says refund amount is $3,776, but I'd like to see it, and I'd like to have it. I'd like, if that is the amount in question, let's see it, let's get it, and then we can go from there.
Okay, understood, Your Honor.
All right, so we'll adjourn it to August 31st at 2:30. And the Zoom is appropriate. We can do it via Zoom.
Yes.
Anything else for the record in docket 20-03116, Mr. Kuipers? All we've done today is adjourned it for 30 days to see if we can get the state of Michigan tax refund.
That's fine, Your Honor. Thank you.
All right, Mr. Brock, you have any questions of me?
Nope.
All right, I'll see you on August 31st at 2:30. Thank you for your appearance, both of them.
Thank you.
Thank you. And then, Mr. Nate, you're here on JP Morgan.
I am, yeah. JP Morgan versus Maniscalco.
All right, let me, I have that. Let's see, Orbit Leasing. I have a civil judgment.
Yeah, I really was just going to update the court. We did file a signed consent judgment earlier this morning. I didn't know if the court had received that yet or not, but that's really all we need to get entered.
All right, because I do have that. I have that. The plaintiff has signed that. I don't have it signed by the defendant.
Ms. Honig?
Yeah, it's the. Yeah, I don't have it signed by Ms. Honig.
Oh.
But if you've reached an agreement on this of the judgment, and you can get Ms. Honig to sign it, then I'll sign it also. I have your name on it, but I don't have Ms. Honig's name on it.
Yeah, no, that's weird. I thought the version I had does have her name in there. So I'll resubmit that. Maybe I got
resubmit it. It could have been lost in the copying of it or the scanning of it, because half of your name is gone also.
Okay. Yeah, I'll resubmit that then. Maybe I'll try to resave it and resubmit it to the court, but that's all.
All right. That sounds good. Orders to follow. Thank you, Mr. Nate.
You betcha. Thank you.
Yeah, no, let me go ahead and. And then Mr. Akanicki, you're here on 26-02372. Is that correct? You're the plaintiff on Muti Abdul versus Balika Biswa and occupants.
That's correct, Your Honor.
Right. I have an ex parte, so we're on the record on that. And Mr. Akanicki, you represent Muti Abdullah. Is that correct?
Yes, Your Honor.
All right. Did you expect Balika Biswa and occupants to be here?
No, we had a hearing a couple months ago, and I just failed to file the judgment, so the court dismissed. And so I was just requesting that this dismissal be set aside, and the court allow me to file a new default.
All right, that's exactly what I thought. I thought you were moving to set aside the initial dismissal. So I will sign your order based on your representations here, but I wanted to hear it because that's what I was theorizing, but I didn't know if that's what really happened. And my notes were imperfect on it. That there was some indication that that it was dismissed, but I didn't know why, and I should have wrote it down and I didn't. So we're set aside the dismissal and re-enter the judgment.
Okay, I think I'll resubmit the judge. I think I have an order on my file, but I'll resubmit the judgment.
I think I've got it right here. If this is, it is ordered the dismissal is set aside and the attached judgment shall enter. I don't know if I had the attached judgment.
They
But if
rejected.
you resubmit it,
I'll
if you
resubmit the clerk's office rejected it when I submitted it the first time, so I'll just resubmit that part.
all right. So if you resubmit it, I'll sign it upon presentation.
Great, thank you, Your Honor. Have a good day.
All right, you too.